The CPI report, Child Protection in Iowa, is brought to you by Vocal Victims of Child Abuse Laws. You can watch our program on Sunday afternoon at 1 o'clock. Again, it's repeated on Wednesday evening at 9:30, all on Mediacom Cable Channel 15. You can email us at vocaliowa@mchsi.com. My name is Don, and my phone number is 276-3956, and John's number is 282-2672. My name is Don Burgmaier, and with me at the controls is my co-host,
John Harvey, and welcome to the CPI report. We hope that we can be helpful in a couple of areas. One is to influence public policy as it relates to child protection issues. And secondly, we hope that we can help you if you call on one of those phone numbers that you saw on the screen a moment ago. We'll have that up before the program is over again, so that if you'd like to contact somebody who has had a little experience, knows a little bit about the Department of Human Services, we can give you some hints. We're not attorneys, so we don't hold ourselves out to practice law the way the lawyers practice law. Sometimes the kinds of things that we do are honorable, so we don't always hold out ourselves to be practicing attorneys. However, and some of those are there are some good attorneys out there. I think you can count the good ones on your left hand throughout the state. But if you've got a good one, hang on to that attorney. But if you need some help,
Is that when you say count them on your left hand? Is that the people with fingers? Or
that's
fingers?
right. That's right. That's right. Right. Okay.
Really surprised you doing that, Terrance.
Right. Right.
Got me too.
You bet. Well, so if we can give you some hints to help you in your struggle with the Department of Human Services, and that is a David and Goliath type of sequence, because you're fighting a pretty big agency, an agency that can outspend you when it comes to legal fees and so forth. So if we can be of assistance to you, we'd be only too happy to pay some attention to your case, give you a hint or two that may be helpful to you in your war against the Department of Human Services. These children are being taken away in greater and greater numbers, and in a recent case, a recent story, we told you about the number of adoptions where children are removed from their homes in unprecedented numbers, far higher than other states, but for some reason or another, no one has called them on it until just recently. But adoption rates are significantly higher, percentage rates are significantly higher than in even California. And someone said, well, that might be because Iowa has a problem with meth. Well, California is far ahead of that. Well, there's a story that, you kind of like to see counterpoint argument in a story now and then. Well, we're going to see that in just a moment. But before we do that, before we do counterpoint, let's take a look at what a conservative individual thinks about families. Families must continue to be the foundation of our nation. Families, not government programs, are the best way to make sure our children are properly nourished, our elderly are cared for, our cultural and spiritual heritages are perpetuated, our laws are observed, and our values are preserved. That came from a great conservative by the name of Ronald Reagan. You see, there are a number of people who still believe that families are the really the core of a good government. Without families, governments cannot survive. You see, families can survive without government, but government cannot survive without families. And our families seem to be being torn apart at at public expense and routed about all over the place, and no one seems to care that our children are leaving in droves and being adopted out to others. And where is there any kind of where is there any kind of calm or peace where that is occurring? There's no stability when you tear families apart. Well, a couple of people did some counterpoint on this subject, and it was started by an editorial that was found in the Des Moines Register, and I'll have you read the part for Kevin Concannon, Don, in just a moment. But first of all, I'll read what Wexler, Richard Wexler, has to say. Wexler and Concannon have this counterpoint called "When is foster care the best option?" One of the things that I have put on the screen from time to time is that the grass is always greener on the other side of the foster fence. In other words, for some reason, our minds have been bent so badly that we make the assumption that no matter what the situation is, if we decide that we don't like a particular family, we can determine that their children would be better in foster care, no matter how bad the foster care is. In other words, the grass is always greener on the other side of the foster fence. And why would that be? Well, the people that perpetuate that sort of notion are the ones who license foster care facilities. And obviously they know if they train the people and they pay the people and they supervise the people, then there is 100% success rate with your children in foster care. Nothing could be farther from the truth. And we've seen studies that show the contrary. Well, this is what Richard Wexler has to say. No excuse for Iowa's high rate of removal of children. No excuse at all. Confronted by the fact that Iowa tears children away from their birth parents at one of the highest rates in the nation, the Register could have demanded answers. The editorial said, if the state errs, let it be to keep children safe. That is an extremely poor piece of logic if you follow that logic. If the state errs, in other words, they say, if we make provision for the state to do something wrong as a matter of public policy, then let them do it on the basis of the fact that the children are safer on the other side of the foster fence. That was written in our Des Moines Register, February the 19th. Instead, it offered a litany of excuses. Maybe it's because child abuse reports in Iowa increased 21% between 2002 and 2003, the Register says. But Iowa also has one of the highest rates of removal in 2002, before the increase. Maybe it's because the meth, the Register says, but Iowa takes children at a rate at least 50% higher than California, long known as the state hardest hit by meth. Maybe it's because Iowa confirms a higher percentage of reports than other states, the Register said, but confirmation is no more than a caseworker's guess is just as subjective as the decision to remove a child. Unless Iowans are inherently more abusive, it's more likely that Iowa is too prone to mislabel parents as child abusers and take away their children. A highly touted redesign will prevent wrongful removal of children, the register says. But if Iowa is not wrongfully removing children, why does Iowa need a redesign? Well, the redesign, of course, is just to wave a flag in front of us, make us think that the agency is doing something grand and marvelous. Hiding behind these myths wouldn't be so bad if only the people hurt were parents. But Iowa's high rate of removal does enormous harm to children. When a child is needlessly thrown into foster care, he loses not only mom and dad, but often brothers and sisters and aunts and uncles and grandparents and teachers and friends and classmates. He is cut loose from everything loving and familiar. For a young child, that is an experience akin to kidnapping. And I've heard you use the term kidnapping, Don. When children...
Who would do that?
Okay. When children feel they must have done something terribly wrong, and now they are being punished, the emotional scars can cripple a child for life. When a child truly is at risk at home, removal has to occur anyway. But if the state is simply confused and the family's poverty with neglect, the abuser is not the parents, but the state. You see, now we're paying a state agency to abuse our children. Makes sense, doesn't it?
No, it doesn't, John.
All this
As a
damage.
parent, I disagree with you.
Okay. But what I'm doing is trying to follow their logic here, and that was the logic.
I can't follow their logic.
No. All this damage occurs even when the foster home is a good one. The majority are. But foster parents are unsung heroes. But the rate of abuse in foster care is far higher than in the general population. It's actually what we figure out 4.2 times higher. It's way higher than if the children are left in their own homes. If the child clearly is in danger with birth parents, then the odds are still better in foster care. But if the problem can be solved within housing aid or daycare or drug treatment, then the state is pulling the child at risk by taking him away. You see, that seems to be the number one treatment mechanism is separation. And that's one thing a child is prone to reject. And you can do it, but you do it at the child's peril. But even that isn't the worst of it. Everyone knows how badly caseworkers are overwhelmed. They often make bad decisions in both directions, leaving some children in dangerous homes, even as more children are taken away from homes that are safe or could be made safe with the right kinds of services. The more that workers are overwhelmed with children who don't need to be in foster care, the less time they have to find children in real danger. So they make even more mistakes in both directions. Why not consider a more reliable measure of whether a system is keeping children safe, the rate at which children left in their own homes are re-abused? I'm not sure that is a real good measure because, you see, there again, it is at the whim of a social worker to determine if the child is re-abused. You know, if their first notion was wrong, it's likely that the second case against that child could be wrong. Iowa takes away children at a rate at least 2.5 times greater than Alabama and 4 times greater than Illinois. Yet in both those states, the proportion of children re-abused after being left in their own homes is lower than Iowa. Is somebody trying to pull something on us here in Iowa? The Register's editorial is filled with maybes. The children's lives are on the line. That's not good enough. The states, it is said, are laboratories of democracy. Why not go to Illinois and Alabama and start reading the lab results? Richard Wexler, writer of this article, is executive director of the National Coalition for Child Protection Reform. I think we're ready for reform. Now we're ready to hear Don Burgmaier as he reads what Kevin Concanon, director of the Department of Human Services, says here in Iowa. Don?
He makes me laugh sometimes, John. This is what he says. These days, as director of the DHS, I often carry a single sheet of paper with 6 full-color bar graphs that are updated every 3 months. It's our digital dashboard, telling me at a glance how well the department responds to child abuse. So he's interested in how well the department responds to child abuse, but he's not interested in the pain that the children and the parents go through, the whole family goes through. He goes on to say, so how are we doing? Better, but not good enough. The standards played on the dashboard came from a tough question that the federal government started asking every state child welfare agency a few years ago. Does your state program work? Until then, we asked process questions. We asked, did you identify the correct service for the family of the abused child, like counseling? Did you perform that service? We still ask those questions, but additional questions test our results. Standards are high. Here's how Iowa has performed. If a court temporarily removes a child from the family for the sake of safety, do we minimize the number of placements in Iowa? The number is yes. Terrance, I want you to listen to this. If a court removes a child, is that child safe from abuse in foster setting? Near perfection is required, and Iowa meets the standard. If a court removes a child, is that child safe from abuse in the foster setting?
Well, I think that begs the question. I mean, you don't know. I mean, according to the statistics that John just read, you're not. There wouldn't be.
Really? I think he would be leaning toward the fact that the children are safe there. Of course, we report quite often.
According to statistics.
Really?
Did you notice they used the word perfect in talking about foster care? I don't think the word perfect belongs in any syntax, in any sentence that's talking about removal of children from the home.
Okay, he goes on to say, if a court terminates parental rights, is Iowa quick to help find a permanent adoptive home? Iowa is twice as fast as the federal standard. If the child must be removed from the biological family, are we quick to reunite most of them? Keep in mind, what is the reason for removing a child? Who makes that decision for removing the child in the first place? It's Greedy Fingers DHS. Money, money, money. So he goes on. In Iowa, the answer is yes, by a mile. He says, if the child must be removed, are we quick to reunite most of them? Well, from what we see, I don't think so. But he says yes. I mean, he's telling the public that, but the parents out here that lose their children, they know the other side of the story. He goes on, but we're changing the way we count, and this measure might be in jeopardy. Sorry. No, I'm really not. Beginning this summer, it won't be a successful reunion unless the child is safe at home for at least 6 months. Until then, it's just a visit. I add in the words supervised visits, so they got control of that family, so that they know they can make termination of parenting rights in the end. That reminds me of this United States Supreme Court ruling, Santosky versus Kramer. I haven't said it for a long time. Let's see if I can remember that quote. The DHS has the power to create history, and they do it as soon as they grab a child. They're out there to win. They want to see that child go into misery, and well, I can tell you a lot more. Of course, we always do, but he goes on. A glance at the dashboard shows we need improvement in two areas. One is the bounce back rate. Oh yeah, the children are in foster homes on an average of 16 times before they hit age 18. And then the next home they go to, with training of DHS, they go into prison. So I don't think that's good. One is the bounce back program. Of all the children reunited, do most of them stay out of the foster system? Yes, but not nearly enough to meet the standard. Oh, does he mean he wants more in foster care? Yeah, I'm sure he does. It's our worst measure, but it will improve when we change our counting method. Oh, wow, he's going to improve things by just a change of the counting method and improve practices. I wouldn't hold my breath on DHS's improvement. He goes on. The other measure deals with abused or neglected children who are kept in the home while the caretakers receive services, such as parenting skills. Of course, they teach you, but you'll never come out ahead with their teaching. He goes on. Are these kids safe from abuse or re-abuse or neglect? Iowa is 7 percentage points short of the required 94%, and we must improve, or they might lose a little money, huh?
Or we must fudge with the statistics.
Oh, yes. These are the measures that count. Our critics tend to oversimplify, and focus on single measures. For example, Iowa is no doubt above average in the rate of removal. At the same time, the total rate of Iowa children in out-of-home settings is below average. If we were high in both, I might be worried. To get better results, we have redesigned our child protective system. Our system is better focused and demonstratively more family-oriented. We now have service decisions based on risk, age of the child, and abuse history. The department keeps management of cases where risk is highest. I'll inject here, I've said this in the past, one of the biggest risks to a child is if a parent takes them to church, or something along that line. DHS doesn't go for that at all. Our innovation will benefit thousands of families with low or moderate risk, most of whom Iowa never helped before. They are eligible for family strengthening, assistance from a private agency operating under an incentive contract. It's free and voluntary for families. We are expanding the use of intense upfront counseling for fragile families. We are expanding community partnerships. We are simplifying the tracking and documentation of child abuse cases. We are referring low risk and unfounded cases to community programs. Of course, we've been talking on the air how dangerous that is, too. We are promoting alternatives to custody relinquishment. We are trying harder to find family relatives who will help when the child is at risk. Oh, I could almost laugh over that one. Well, there's some families feel like they're being helped, but there's a lot of families say, hey, we offer our services here, our grandparental desire to help our grandchildren, and the DHS just looks the other way. He finishes up. We are measuring these things well. There will be controversies, but we're focused on the measures that count. Like the old saying, things that get measured get done. I believe the Bible also, it says, merry heart doeth good like a medicine. I appreciate
Yes.
the opportunity to laugh.
It
Terrance?
also says measure twice, cut once.
That's right.
Measure twice, cut
It sounds
once.
like they measured once and cut twice.
Which Bible are they reading?
The
Okay, John.
VHS version.
Okay. It's interesting to see point counterpoint here. The people who are the ones who are controlling DHS are the ones who do the counting. They're the ones who make the reports to the government and says, no, we don't move these kids from foster care to foster care to foster care, but you and I know that they are moved from foster care to foster care. And the children are not totally against that, because every time they move from one foster care placement to another, they get an allowance of $200 to buy their new Nikes or sweaters or whatever they want to buy. $200 every time they move. So best that we move, we get more money for the kids. To me, I think it would be a heartbreaking. The whole idea of foster care would be heartbreaking. Now we're going to turn to Terrance, because not just a whole lot of time left here, and you've got a bundle of things to talk about here. Terrance?
Yeah, well, I can talk fast and be brief. How about that? One of the things I wanted
Close
to
to
talk
the mic.
about was
Yeah.
was that better? Okay. One of the things I wanted to talk about, John, which I don't know if it's tangentially related to what you're talking about, but I always say that the judiciary, if they kept these bureaucrats in line and ensured the fairness of proceedings for families and children, then we wouldn't be in this situation, whereas you're having to have a show to talk about the DHS, and I'm having a segment to talk about the courts. So that's just something I always like to say to kind of make it relate to what is transpiring there. But one of the things that we all got to keep in mind here, in the light of in the wake of all this talk the judiciary has been having the past several months on revamping the code of conduct for the prosecutors here in the state of Iowa, I thought it timely and also very necessary to talk about the code of conduct for judges. Everybody has a code of conduct, whether it's spoken or not. People in office should have a code of conduct and stay in line with that code of conduct so that it ensures accountability and fairness of the administration of their duties. The Iowa Code of Judicial Conduct, and I pull this off the website, if you can show this for the audience, Don. The Iowa Code of Judicial Conduct is on the website for the Iowa Supreme Court. And I'll just paraphrase here. Here's a copy of it right here for you. It's broken up into segments known as judicial canons, and there's like 6 or 7 of these canons here. Just read through the canons here real quick if you can. I think there's another copy. Should be behind there, underneath. Iowa Code of Judicial Conduct. Basically, one of the first says that the judge should uphold the integrity and independence of the judiciary. Okay. Number 2, a judge should avoid the impropriety and the appearance of impropriety in all activities. Number 3 says a judge should perform the duties of office impartially, I should say, and diligently. Number 4, if you could scroll to number 4. Okay. Number 4, if we a judge may engage in activities to improve the law, the legal system, and the administration of justice. Again, that's not anything to do with any code of conduct to regulate their activity. A judge should regulate extrajudicial activities to minimize the risk of conflict with judicial activities. Okay. And the last, I think, one of the final ones, compensation received for quasi-judicial and extrajudicial activities. And it just says that some of the stuff that they do should not, they should not get compensation for stuff related to cases and stuff like that. A judge should refrain from political activity inappropriate to the judicial office. Now we have these judicial canons, and we have a body that's in place in the state of Iowa to enforce these judicial canons, or supposedly to enforce these judicial canons since 1972. The Iowa Judicial Qualifications Commission was empowered to hear complaints about the judges for violations of the canons of the judicial conduct. And since 1972, surprisingly, over 32 years ago, we've had less than a handful of judges actually removed from office here in the state of Iowa. And you know, some people will say, well, we must have some really great judges then to never have to have anybody removed 4 and 32 years. I think that some of the cases that we highlight on this show that that cannot be the case. Just in the few instances in which we've shown striking flaws in not only the judicial process, but in some of the reasoning coming down from the judiciary, or lack of reasoning, I should say, and impropriety, and the appearance of impropriety. I think that we can honestly say that there is something that's truly wrong and amiss that's going on in the judiciary here in Iowa and the United States in large. That's why our group has been advocating that judges be voted out in Iowa on the retention vote, which is we're one of the few states that we can actually vote out judges every 2, 4, 6 years or 8 years, depending on their rank of their judicial office. Another thing that I wanted to share in light of this Iowa Code of Judicial Conduct is an article that we've harped on here the past couple of weeks from Anthony D'Amato. He's a Northwestern law professor. He's got a really good article online, The Ultimate Injustice When a Court Misstates the Facts. He goes through in this article, which is in the Cardozo Law Review, and states and examining a case, and he states, and I'm paraphrasing, even demonstrably false things can be stated as factually accurate in a judicial opinion because the reader typically would not question the accuracy of what a judge reports as the facts. And he goes on to state about the legal profession and their training through law school. We encourage glibness, we penalize honesty, we applaud fabrication, we discourage sensitivity of justice. And we tell our students that it is not the attorney's job to make a judgment about right or wrong, but rather to represent the client irrespective of right or wrong. And they talk about that training, which we take pleasure in imparting in our classes, has its effect upon those 1 or 2 students sitting in our classroom who will someday become judges. They too can become cynical by our pervasively amoral, technocratic approach to legal solutions. And he asks the question, do judges routinely display a casual attitude toward the facts of a case? I suggest that practicing attorneys be asked whether they have had cases where judges' statements of facts were false. Every practicing attorney to whom I've asked this question has responded in the affirmative. Some have told me that the practice is unfortunately quite common and that judicial misrepresentations of the facts of cases has produced a crisis in their professional lives. They feel that their work is subject to the whim of judges who play God with the facts of a case, changing them to make the case come out the way the judge desires. And there was a Professor Monroe Friedman who spoke to the Federal Circuit Judicial Conference who said, he's had enough of judicial opinions that bear no relationship to the cases that have been filed and argued before the judges. And he said, I am talking about judicial opinions that falsify the facts of cases that have been argued, judicial opinions that make disingenuous use of or omission of material authorities, judicial opinions that cover up these things with no publication and no citation rules. So this is what we're talking about here. We've got a judicial code of conduct here which does not even mention these things. The misstatement of facts, the omission of authorities that people are citing to rely on to argue their case. You know, like say for instance you go and you file something based upon a Supreme Court case, and the court, say for instance it's an Iowa court, they don't even mention that case. Goes on all the time, and we're going to show that, and we're going to demonstrate that. It's went on, the omission of facts has went on in several cases, and they've went on in cases involving even the people that are on this show, which we're going to talk about here.
That's right.
One case I think that we should highlight, you know, I don't know if you have the records there, again, John, but
Sure do.
do you have the records of that case there? All right. This case is involving a fellow by the name of Terrance Walker. You guys don't recognize that name as me. This case, if you can show this legal opinion here. All right, there we go. Now this is a case that was filed by the Iowa Court of Appeals here in February, just a few weeks ago, February 24th, I believe. Case number, if you want to look this up, it's online on the Iowa Supreme Court case, or on the Iowa Supreme Court website, I should say, 4-862. Also has another number, 03-1173. If you can pan down to the highlighted section. All right, this is a case involving me. Now, brief facts is that I had signed a subpoena saying I served a witness, and I didn't serve him till the next day. Had a girlfriend's daughter give the subpoena to him. Well, you know, the thing is that you can't serve a subpoena upon a 12-year-old. You have to serve their parents. But since I had complained to a few judges in Story County, they found fault with this. They found that there was something criminal amiss. Even though the court did not even act on the subpoena, said it was basically up to the parents to come in and bring the child in, and knew that I hadn't served the parents a subpoena as required by law. Well, guess what? If you've complained, judges, that is a criminal act here in Iowa. I'm here to enlighten folks who do not know. If you do anything that is not even, it can't pass criminal muster test for anybody else. If you complain a judge, that is criminal activity. And guess what? In 1998, the Supreme Court of Iowa affirmed that opinion of the trial court in Story County that that was criminal activity. Well, if you read along on that opinion there, this is from February 24th of this year again. It clearly states in the record, and I'll go back to our citation here when the court misstates the facts. Even demonstrably false things can be stated as factually accurate in a judicial opinion because the reader typically would not question the accuracy of what a judge reports. Well, here we have it. We have some stuff that is demonstrably false. If you read the opinion there, go back to the top there, first page, it actually says, in the highlighted section, it says that by his signature, Walker certified he served a minor witness. Well, a minor witness can't be served a subpoena. Well, Iowa Supreme Court said, well, that's capable of influencing the court. That's perjury. That's capable of influencing the court. Well, if we look at the statement of the court, we'll actually see that in this citation here, well, this is actually citation of the transcript of what the court said. Go up a little bit there. So, well, in that little highlight, the little section in the middle, go down. He says, well, let me call the school back, Mr. Walker, and tell them that it'll be up to them and Mr. Bearden's parents to decide whether they should bring him in this afternoon, and we'll continue to get started with this trial. Well, you know what? If it's up to the parents to decide whether or not they're going to act on a subpoena what hasn't been served on them, then I'm sorry, Iowa Supreme Court and Iowa Court of Appeals, that's not capable of influencing the court as required by the perjury statute here in Iowa. Now, what they go on to misstate, again, like I say, even demonstrably false things can be stated as factually accurate in a judicial opinion. If we go down to the first page again with this, with the legal opinion, it clearly states, or on the second page, I should say, on the legal opinion, it actually states that, well, these facts don't have any bearing or nothing like that on this opinion, and I'll quote from what they said. Well, you know, because I brought up the fact that my attorney that handled my first appeal didn't put this stuff in there. Well, they say, to the extent that facts and arguments are relevant to the perjury or tampering convictions, they were clearly known to the Supreme Court or have so little effect upon the convictions that their conclusion in the direct appeal wouldn't have created a different outcome. Well, how is that so? If it's not capable of influencing the court, the facts speak for themselves. The judge denied the subpoena. If it was capable of influencing the court, he would have acted on it. Not sit there and told me that the court is going to wait until the parents call. One other thing I wanted to point out in that brief, one other thing, they also claim that in the brief on the page, I think it was page 7 or 8, there was a citation to the trial record, and then we would in that brief that's on the table already. There was a judge in this case that handled their initial trial that actually, on this page here, here we go, yeah. Now, the Court of Appeals goes on to state that, well, there was no change in the state of the law because this is clear. This is a clear violation of the tampering provisions as well. Well, if we look on page 7 here on this brief, which subsequently filed, if you look up at the top there, there's a citation to what the court said at the trial court level. And this shows clearly that this was not a clear rendition of a criminal statute. There was no, in other words, due process clause, which I was raising, which the Court of Appeals ignored clearly. The due process rule lenity argument states that criminal statutes must plainly and unmistakably prescribe the actions for which they're being used to perpetrate upon the citizens. Well, they made no ruling on this, but this is kind of thing that goes on all the time in the Court of Appeals and the Iowa Supreme Court here in the state of Iowa. This is what they're saying. They're basically saying that this statute was plain and clear. Well, the use of this statute, if it was plain and clear, you would think that a trial judge would know that the meanings of the words in the statute as they were used would be certain to the judge, definitely. Well, this is what the trial judge said. Well, I remember the argument you raised, Mr. Walker, and I will candidly admit to you that there is a distinct issue in that statute what the word falsify means. And I will candidly admit to you that there is an argument that falsify means altering a document and make it false. And I understand evidence doesn't show that. But there's another definition of falsifier that might apply to this case. There's no decision of the Iowa courts of appellate courts that gives much guidance in this regard. So I candidly admit that you got an argument here, and I understand what you're saying, and you may ultimately be right. I'm not sure. Well, ladies and gentlemen, you're not supposed to guess when you're doing a criminal matter and you're adversely affecting the right of a citizen. It is rooted in the fundamental, it's fundamental and rudimentary in the Due Process Clause of the United States of America that people should not have to speculate, much less a judge. People should not have to speculate as to the meaning of a word. And when a court goes to enlarge the meaning or to implicate other meanings which do not plainly appear clear, then we have what's called a violation of the Due Process Clause. And that's what we should have embedded within the Iowa Code of Judicial Conduct, that these type of things should not go on. Moreover, we should not have types of things that go on where the courts omit facts, misstate facts, and omit ruling upon specific arguments raised to courts, which is what we have here in this case. I've got a guy here that I've also wanted to contact. We've talked about this issue a couple of times. Two fellas out of New York. They have a website called Americans for Legal Reform. Guy by the name of Carl Lanzera and his buddy Harvey Cash were at a courthouse a few months ago and were arrested for telling lawyer jokes. Just wanted to see if we can get them online here for a second and have them tell us about their story. Maybe you can go over something here real quick while I get them on the phone.
I was wanting to refer back to your Canon 7 you were talking about. Just a quick comment. A judge should refrain from political activity inappropriate to the judicial office.
Carl?
How many judges out there, a few judges, are having relationships with the county attorney women and get in trouble? Once in a while that happens, so I think that would apply. So we'll see how Terrance is coming along with his telephone call.
Well, I think we'll get him here in a second if I can get the phone working here. There we go. Yeah, is this Carl? Yeah. Hey, Carl, how you doing, buddy? This is Terrance. I'm doing great. This is Terrance with VJO, Vote Iowa Judges Out, and also with Vocal Iowa here. Okay. John Harvey and Don Burgmaier. And we just wanted to call you about your incident there. What happened out there in New York at the courthouse? I guess first tell us a little bit about your organization and how you founded it.
Well, we started a group about 15 years ago, Americans for Legal Reform.
Okay.
We have a website, Americans number 4 Legal Reform, www.americansforlegalreform.com.
Okay.
And we're a 501c3 nonprofit organization.
Okay.
And we help educate, we try to educate people on the legal system, how inept and corrupt it is.
Okay.
We do such things as court watch. A lot of times people go to court and we advocate bring a court watcher with you. A lot of times people say, I have a lawyer. That's not a court watcher. Lawyer doesn't work for you. He works for the courts. He takes his allegiance from the state, the Bar Association, the courts. You're the last on the list. You have to pay the bills, that's all. So you should go to court with court watchers, people with a yellow pad and a pencil, and let them take notes. It's very intimidating when somebody is watching these scoundrels with a pad and pencil. You have to go through the metal detector when you go to court. I'm sure out there the same as out here over here in New York. And the metal detector is not because they're afraid of guns and knives is because they're afraid of tape recorders.
Okay.
So my friend Harvey, who you see on the website, who's been active in the group for the past 15 years, he was arrested for a DWI about 2 years ago.
Okay.
And he asked for a trial by jury. They don't want anyone to know that you can have a trial by jury for a DWI. What would happen to the courthouse if everybody asked for a trial by jury? So they have been making him come back every month, every week for the last 2 years. And I went with him on this particular Monday back in January. It was so cold out that we saw a lawyer with his hands in his own pocket. And
okay.
you guys are a little slow out there.
Yeah, we're Iowans. Bunch of cows and pigs out here. So yeah, we're
the kings. We say the kings don't have to go through the metal detector. Do you have metal detectors out there in all?
Yes, we do.
Yeah, well, the kings don't have to go through the metal detectors. Only the peons have to go through the metal detector.
That's right.
Meantime, it's a proven statistic that lawyers have twice the substance abuse rate as the rest, as humans. We don't consider them humans. The statistics are about 10% of Americans have some kind of drinking or drug abuse problem. And, and the statistics for lawyers is 25%. And that's by the Bar Association. They admit that.
Well, maybe they've been going to the bar too much.
Yeah, that's right. They go to the bar too much is absolutely right. You heard about the lawyer that couldn't pass the bar?
Uh-uh.
Well, that's it. So we were waiting in line, and as I said, it was so cold, we saw a lawyer with his hands in his own pockets, and we started telling a few jokes, and someone in front of us, just in front of us, turned around and yelled, "I'm a lawyer, shut up." So we didn't know, that really intimidated us, and we really turned on the steam, and we started telling a lot more jokes. You heard about the terrorist that captured a plane full of lawyers and threatened to release one every hour if he didn't get his money?
No, I haven't heard that one.
Why did they bury lawyers 100 foot down and everyone else 6 foot?
Deep down, they're good.
Deep down, they're nice guys. How many lawyers does it take to change a light bulb?
I don't know.
How many can you afford? What's the difference between a lawyer and a sperm?
I don't know.
A sperm's got a chance in a million of becoming a human. So, I mean, we had everybody laughing, and in fact, there were several policemen outside walking back and forth, as they usually do, and they were giggling too, but they're not allowed to show it, so they kind of hide their face. And we went up, and Harvey went around the metal detector because now he has a pacemaker. And they only let one person in at a time, and then I was the next one in. I then went through the metal detector, and we got to the other side of the table, and the lieutenant told us that we were disturbing the peace outside. And we denied it vehemently. Well, next thing I heard him yell, "Arrest them!" And they spun us around. They put our handcuffs on. They put handcuffs on us and pushed us down a hallway into a room and frisked us, made sure we didn't have any weapons. Meantime, Harvey is 70 years old. I'm 65 years old.
Oh, that sounds familiar.
They took our wallets and did a search on us, made sure we had no warrants outstanding. 4 hours later, they charged us. They gave us a ticket for making a loud noise. Originally, they tried to charge us with disrupting the outside, but they crossed that off and they said making a loud noise. And the court officer then shook our hands and said, "You guys are real nice guys." 4 hours later, and told us if there was anything we could do, let him know. I said, "Yeah, let me know the name of that lawyer that caused all this ruckus." He said,
So the lawyer told him to arrest you?
"Yeah,
Oh my
that's
goodness!
why he arrested us." And
Wow.
you know, lawyers are officers of the court, and in the pecking order of officers of the court, they're above the court officers themselves. So when the lawyer tells a court officer to do something, he does it quick.
Wow. Now what happened? How this transpired? We only have like about a minute left, so I'm gonna have to be brief. What ended up happening to the case?
Well, they just dropped the charges against me, and they had a grand union investigation. I mean, a grand jury investigation. and I had to testify against Harvey. They wanted they had three district attorneys depose me in front of 23 grand jury, and he was found not guilty.
What a waste of tax dollars.
What's that?
What a waste of tax dollars.
Well, we got home. It cost the county $100,000.
Wow.
They had 3 district attorneys depose me. They only do that if you murder your wife.
Yeah.
And that's what the same. So when we got home, we called the newspaper, and once the AP picked it up, it went around the world. If you go to Google and you push lawyer jokes arrested Carl and Harvey, you will see 15,000 stories around the world.
Wow. And I heard you guys were on a Comedy Central show as well.
We're on over 25 television shows, including Comedy Central. We did a knee slapper for them. They really liked it. And they fit that in with tort reform because George Bush is for tort reform. And they just showed how stupid the lawyers are and how stupid the system is. So we accomplished, I should say the lawyers accomplished more in 15 days than we've accomplished in 15 years.
Yeah.
The publicity was outstanding.
Well, that's good that you guys fought back and won. Hey, we're gonna have to break.
We're gonna quit our day job. We're gonna do stand-up lawyer jokes.
Yeah.
But I've been sent to the Joker Protection Program. They changed my Social Security number.
What's the sign around the courthouse now?
Oh, they're putting signs all around the courthouse now. Joke-free zone.
Well, here in Iowa, our host here, John Harvey, I think they're going to be putting signs on there that say no camera zone.
Okay.
Because he had a similar incident.
Yeah.
They don't,
Okay.
But we've got to cut off now, Carl. We'll give you a call back.
Well, you can hold him on there.
Okay. Thank you for that communication from Carl. That was a good telephone communication, and we will see you next week.